Mr. Interpreter, I don't believe Mr. Azula needs your services, so I think we're done with you for today.
No, I can speak
Thank you very much, Your Honor. Have a good morning.
Thank you, you too. All right, Mr. Azula, the court in your case finds probable cause for aggravated assault with a firearm.
I don't know why I'm here today. I've been in the county jail for 17 days. I don't know why I'm here at first appearance.
Are you Corasir Azula?
Yes, ma'am.
All right, sir. In your case, on or about September 15th, 2022, this incident occurred. Were you in jail on September 15th, 2022?
September 15th?
Yes.
No, ma'am. I was on the streets. I came to jail.
Okay, so that's when this incident occurred, and the court is informing you that the charge is aggravated assault with a firearm. I am ordering a bond in this case of $5,000, ordering you to have no contact with the victim.
Hold on, ma'am. I already have that charge. How am I being charged twice with the same charge?
Well, I don't know.
Can you please have the court people look it up? I already have that charge, ma'am.
No, I don't think so, sir. But anyway, I'm ordering you to have no contact with the victim, possess no weapons and no firearms, and surrender any weapons and firearms in your possession to law enforcement within 24 hours of your release. Now, sir, given the fact that this case indicates that it happened on or about September 15, 2022, I'm going to ask the state if the state would confirm that this isn't a duplicate charge.
Your Honor, there's an indication that it is an add-on. If you look at the face sheet, however, Mr. Azula is correct. He does have aggravated assault with a firearm under 22 CF 11061. He also has it,
Okay, but he's not going to know what that means. I mean, the victim in this case, we want to be sure is not the same victim. The victim in this case is Jefferson Bouvier. Do we know if there's, if this is a duplicate, or are we sure that it's not a duplicate? That's all I'm asking. I just want to confirm that this is not a duplicate.
sure, Your Honor, if you give me a moment, I'll look at those
Sure.
2, 3 other cases, 4 other cases.
And it doesn't, and it could be, the victim could be the same in the other case. I just want to be sure it's not a duplicate.
Please, Your Honor.
Let's see. I am looking at. The case I'm looking at, Your Honor, occurred on September 18th, and
So this one was September 15th, so that's two different dates. So that means that one's not a duplicate to this one.
right, Your Honor, and the victim is an employee of JL Towing,
Okay.
and that's 22 CF 10996. Let's see, what's the next one?
So that one's not a duplicate.
Can I please have the affidavit for that, ma'am? I don't even know nothing about this charge.
We're not providing you affidavits at this time, sir. We're just going to confirm whether anything is a duplicate or not. We want to confirm that we don't have printers and the ability to just go through all your cases and give you an affidavit. Now, that will be up to your lawyer. Now, I am appointing the public defender to represent you, but we're going to at least confirm that there's no duplicate, okay?
In case 22 CF 11061, the victim is Mohammed Najari.
What was the date of that incident?
It's at a 7-Eleven, and it appears as though it would be September 22nd, Your
So
Honor.
that's not a duplicate because the victim is different, the location's different, and the date is different, so that's a different charge.
I apologize. I just seen aggravated, so I know I have a charge like that, so
We're just gonna confirm that this is not a duplicate. Once we confirm that, we'll be able to release you, or, well, not release you from jail, but release you from this hearing and let you go back to your cell.
In 22 CF 11187, the victim is Christina Maddox.
Different victim. And so I don't think we need to look at locations and dates. The victim's different.
Yes, ma'am.
Do I have to keep going?
No, ma'am, no, ma'am.
I think he's satisfied now that this is not a duplicate. Did I already order the conditions? All right, thank you, sir. You're excused now.
Thank you.
Larry Odoms. In your case, the court finds probable cause for fleeing and eluding a law enforcement officer with lights and sirens. Bond is set at $4,000. And driving on a suspended license, bond is stayed at $500. Condition of bond is that you not drive without a valid driver's license. Thank you, sir.
Take this, yeah.
Jose Batista Acosta. Mr. Acosta, the court finds probable cause for criminal mischief. Bond is set at $1,000. You're ordered to not return and have no contact with the victim. Thank you. Hiram Fordhams. Mr. Fordhams, the court finds probable cause for petty theft and sets a bond of $5,000. Orders you to have no contact and no return. Alfredo Torres.
He refused, Your Honor.
I don't have probable cause paperwork on this case. I'm unable to find probable cause. I'll reset it for 24 hours. State, you need to provide me with the PC paperwork. Danny Doss. In your case, can't understand my own handwriting. All right, I got it. And this, the court finds probable cause for robbery. Bond is set at $2,500. And battery, bond is set at $100. You're ordered to have no contact with the victim, possess no weapons and no firearms, surrender all weapons and firearms to law enforcement within 24 hours of release, and not return to where this incident happened. You also have a violation of probation, for which bond will stay at no bond, and another violation of probation for a case in Polk County, and bond will stay at no bond. Thank you, sir. Johnny Miller. Johnny Miller, not present? Oh, that's Mr. Miller. Mr. Miller, in your case, for count 1, attempted first-degree murder, I do find probable cause. The court's going to set a bond. State, do you have any recommendation as to a bond?
That's punishable by life, Your Honor. I would ask defendant be held no bond.
And I was amenable to setting a bond, but if the state objects, then the court's going to set no bond. Aggravated battery with a deadly weapon, count 2, bond is set at $3,500. And aggravated assault with a deadly weapon, bond is set at $2,500. You're ordered to have no contact with the victim, not return to the location where this incident occurred, surrender weapons and firearms to law enforcement within 24 hours of release, and possess no weapons and firearms as a condition of release. Thank you. Oh, these are arraignments. Anton Edward Douglas, you're being arraigned on a charge of battery, domestic violence. The public defender was previously appointed.
I apologize, Your Honor. One moment, please. Sorry, Your Honor, I apologize.
No, no problem. Does he enter a plea of not guilty?
Yes, Your Honor, he'll enter a plea of not guilty and set it for the next PTC date.
All right.
It'll be Division 50, November 18th at 9 o'clock in courtroom 4E.
Thank you. Cameron Armand Jackson. Mr. Jackson, you're being arraigned at this time on a charge of resisting an officer without violence.
Your Honor, he's going to resolve in a plea. He's going to
Okay.
enter a no contest plea. I just need 1 second to go over the form with him again.
Okay.
Yes.
1 second.
I apologize. 1
Mean
minute.
1 minute.
Yes. No, they're not going forward on that.
Does he wish to proceed, counsel?
Yes, Your Honor, I just have to find his plea form.
Okay. Counsel, in his case, are you able to stipulate to a factual basis, as I did not review the factual basis in this case?
Yes, Your Honor.
All right.
He did review the plea form when I was back there. I just wanted time to make sure that the felony case wasn't going dismissed.
Okay.
For the resisting officer without violence, adjudication of guilt and credit time served. For the trespass, adjudication of guilt, credit time served. No return to Mill Creek, apartment 500, location 500 West Amelia Street, and cost of investigation of $114 to UCFPD, Your Honor.
All right. And I think you indicated a no contest plea, is that correct?
Yes, Your Honor.
Okay. Mr. Jackson, sir, is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read the plea form before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol or drugs and medicine?
Ma'am.
Do you understand that a conviction on your case will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
All right, counsel stipulates to a factual basis. I'll accept that stipulation, and I find you to be alert and intelligent. As to count 1 and count 2, you're adjudicated guilty and ordered to serve 39 days in jail with 39 days credit. Is that the amount he has? Yeah. Yes. Okay. And further, you're ordered to not return to Mill Creek Apartments at 500 West Amelia Street in Orlando, and pay costs of investigation in the amount of $114 to the UCF Police Department. You must also pay all of the mandatory court costs associated with this charge.
Okay.
I also am going to order a condition that you not return to the location where this incident occurred. I already did that. Let's make it within 180 days of release. All payments should be made, and I am ordering your release as to this charge. Do you have any questions?
No, ma'am.
You have a right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. All right, thank you, sir.
Thank you.
Stephanie Lampo,
She'll be entering to a no contest plea, Your Honor.
all right.
For the resisting officer without violence, there'll be adjudication of guilt and credit time served. For the criminal mischief, it's adjudication of guilt and credit time served. For the petty theft, it's adjudication of guilt, credit time served. No return to Walgreens located at 5501 South Kirkman Road. Restitution is ordered and reserved to the amount of $28.84, and cost of investigation to Orlando Police Department of $138.14.
So is the restitution agreed upon or reserved?
It is reserved, Your Honor, but there are two separate amounts. One is for a petty theft, and then there is also damage. So the $28.84 is specifically for the petty theft.
For count 3, and reserving on count 2?
Yes, Your
Okay.
Honor.
Got it. And time served, is it 16 days? Okay. No, thank you. Ms. Lampo, ma'am, is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read this plea form in its entirety before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine today?
No, ma'am.
Do you understand that a conviction on your case will subject you to being deported if you're not a U.S. citizen?
Yes, ma'am.
Counsel, do you stipulate to a factual basis as to count 1, count 2, and count 3?
Yes, Your Honor.
All right, based upon stipulation of counsel, I find there's a sufficient factual basis, and I find you to be alert and intelligent. As to both count 1, well, all counts, 1, 2, and 3, you are adjudicated guilty. You are ordered to serve 16 days in jail with credit for 16 days time served to run concurrent on all counts. As to count 2, additionally, I am ordering restitution and reserving jurisdiction as to the amount of the restitution. As to count 3, I am ordering that you not return to Walgreens at 5501 South Kirkman Road and ordering restitution in the amount of $28.84. I am further ordering all mandatory court costs of investigation to Orlando Police Department in the amount of $138.14. All monies must be paid within 180 days of your release, and I am ordering your release as to this charge, or these charges. Do you have any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you. Tybee O'Neill Oliver.
Medical, Your Honor.
All right. Do you want to waive arraignment or just have this set for pretrial?
Yes, Your Honor.
Okay. Case be set for pretrial.
Division 82, pretrial will be November 9th at 1:30 in courtroom 9B.
Thank you. Brian Scott Parsons.
Also medical, Your Honor.
All right. Would you like to waive arraignment in that case as well?
Yes, Your Honor.
All right, waive and set for pretrial.
Division 62, it'll be December 15th at 8:30.
Joya Sierra Wilson. In your case, you're here to be arraigned on a charge of count 1, battery, count 2, resisting an officer without violence, count 3, resisting merchandise recovery, and count 4, petty theft. Ms. Public Defender, does she wish to enter a not guilty plea?
Yes, Your Honor. I apologize.
The court will enter a not guilty plea and set your case for pretrial.
It's gonna be Division 82, November 8th at 1:30 in courtroom 9B.
Thank you. All right, I got 2 stacks, and I don't remember who's
You don't need
next.
to take that, sorry.
This one. Thank you. Okay, strike Brea. Court finds probable cause for the charge of trespass on property after warning. Bond is set at $500. You're ordered to not return as a condition of your release. Thank you.
I do apologize. 1 second, Your Honor. I can't seem to find his paperwork. I apologize.
It's last name Araia.
1 second.
Defense, if it helps, there was no offer.
Okay. Thank you. Okay, that's fine. That's fine.
Thank you. Leah Bates. Medical. Would you like to waive?
Yes, Your Honor, we can waive.
All right, the court does find probable cause for both count 1 and count 2. Bond is set at $500 on count 1, and bond is reduced to $100 on count 2. No action on the out on bond case. Defendant to have no contact with the victim, no return, possess no weapons, no firearms, and surrender weapons or firearms to law enforcement within 24 hours of release. John Doe. Mr. Doe.
Your Honor, I believe his name is actually Diomedes Cifuentes.
Okay.
Your Honor, in regards to this case, I was trying to challenge PC because they couldn't really identify him, and they couldn't really figure out what his name was when they came to the jail. I'm not sure if that's a PC challenge or not, but I was challenging PC for the trespass, Your Honor.
All right. Well, that name does not appear anywhere in this PC. Sounds like she may have a valid argument. What says the state?
His fingerprints have cleared, Your Honor.
Oh, they've cleared, okay.
I'm sorry, okay, wait, okay. Fingerprints have cleared per,
FDLE?
okay, well, per the pretrial release,
Yes.
staff had indicated that fingerprints have cleared. Does that mean that the fingerprints come back to this gentleman,
Yes. As
Fuentes, C.
visually
Fuentes?
stated, yes.
What says the state now that I have that additional information?
Your Honor, this is a trespass and a conveyance. He was found in a stolen vehicle. He was not the driver, he was a passenger.
There's also a resisting an officer without violence.
Yes, Your Honor, that would be, some charge it as a resisting, others charge it as a, it's not giving false information, it is, yeah, well, actually, it is resisting when you refuse to give an
Yeah, it's just resisting. So let's, look here. So we had the officer to arrest him. At what point did the officer get the fingerprints? Do I know? Was it at booking?
Yes, he was fingerprinted here.
Okay. Well, based upon that, then I believe that, I can find probable cause.
Okay, Your Honor. Can I speak to him for 1 minute, please, see if he wants to resolve this case then?
Yes.
Okay.
I apologize for this. For the previous client, the defendant, Leah Bates, she had an out on bond. Did we address that?
So took no action.
Yes, no action. Miss Eugene,
Yes.
so there are multiple conclusions that can be drawn from the way that the probable cause affidavit is written.
Yes.
And one of the conclusions that can be drawn is whether the defendant had an understanding of what was going on. So it could be a competency concern.
Okay.
So I'm asking you, as you talk to him, I'm letting you know that I may have some concerns about competency, and I don't know whether you do or not.
Okay.
So if the concerns about competency are not addressed, then I won't be able to accept a plea from him, even if he wants to plea today. I need you to address that as well.
Okay, no issue. One second.
Okay.
1 minute, Your Honor, I apologize. Yes, Your Honor, we do also as well have concerns in regards to his competency, so he won't be resolving the case today, Your Honor.
All right, I'll enter a not guilty plea. Bond stays at 500 and 100. No contact, no return. Nina Crowder? Ms. Crowder?
Your Honor,
Yes, ma'am.
with regard to 22 MM 6929, possession of drug paraphernalia, the state announces a no information.
All right, Ms. Crowder, the case has been no information by the state. I'm ordering you to be released as to this charge. Thank you, ma'am. Jerry Durisme? Okay. Mr. Durisme, okay. All right, sir, in your case, I find probable cause for trespass on property after a warning. Was there an offer in this case?
There was, I do apologize, Your Honor. Let me double check to see if I have she gave it to.
The offer, Your Honor, is adjudication of guilt, credit time served, and no return to 1045 29th Street.
All right. I will need to be sure that Mr. Durisme has read that plea form. If he needs time to read it, we can pass him and go to the next case.
Yeah, he said he didn't read it, Your Honor. I apologize.
Okay. Does he wish to accept the credit for time served offer and the condition that he not return to 1045 29th Street? I would also order court costs. Does he wish to accept that?
1 minute, I apologize, Your Honor.
Okay. Oh, did you have something, Ms. Keys? No. Oh, okay. Put this thing down here, this little exercise thing for your feet. You just move your feet up and down on it, and it's like a little exercise thing. I don't know what it is. It's like a little ramp, and then you could just go back and forth with your feet. Does he wish to resolve it today?
Yes, Your Honor.
Okay,
And it'll be a no contest plea, Your Honor.
all right. All right, Mr. Durisme, is this your signature here at the bottom of this plea form? Yes or no?
Yes.
And did you read the plea form, sir? Yes or, no, or no? You have to answer out loud.
I scanned over it with my eyes.
Oh, no. We're gonna let you read it.
Okay.
Okay. You can read in English, right?
Yes.
That's why I asked him. He said yes.
Okay. We'll pass your case. Max Weber, Randy Germain? Max Weather?
Yes, ma'am.
All right, I find probable cause in your case for trespass on property after a warning.
Your Honor, I apologize. Client will be accepting the plea to resolve his case. No
All
contest
right.
plea.
Yes, ma'am.
Let's see the plea form. It'll be adjudication of guilt, 5 days OCJ. I believe he has 1 or 2 days for credit time served. No return to 5826 PGA Boulevard, Orlando, Florida.
Has he read the plea form in its entirety?
Yes, ma'am.
Okay. And how much time served does he have?
2 days.
Confirmed it.
Mr. Germain, is this your signature here at the bottom of the plea form?
Yes, ma'am.
And you say you've read it, correct? Are you under the influence of any alcohol, drugs, or medicine today? Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
All right, sir, there is a sufficient factual basis to accept your plea, and you are alert and intelligent. I'll adjudicate you guilty, order 5 days in jail. You'll be given credit for the 2 days you have already served. Further, I am ordering you to pay all mandatory court costs within 180 days of your release from incarceration, and ordering you to not return to 5826 PGA Boulevard, Orlando, Florida. Do you have any questions?
So it'll be this Sunday I'll be released?
Well, today's Thursday. You have 3 more days left. So today will be day number 3, then tomorrow will be day number 4, then Saturday will be day number 5. Unless I'm wrong.
Today is day number 2.
Oh, so I'm wrong. Today is day number 2.
Sunday.
Sunday, yes, sir. On this case,
This case,
okay? You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Good luck, sir. Mr. Jordan Hinkle? Jordan Hinkle, do you want to reset?
Yes, we can roll it over to tomorrow because he does have an offer to resolve his case.
Okay, reset due to behavior.
Okay.
Paulette Rither? Oh, this one's ready? Mr. DeRismay is now ready, so recalling Jerry DeRismay. Mr. DeRismay, have you now had a chance to read this plea form, the whole thing? I'm talking to you, Mr. DeRismay.
Yes, ma'am.
All right. Did you have any questions about anything on this plea form? Yes or no?
No, ma'am.
Are you under the influence of any alcohol or drugs and medicine, Mr. DeRismay?
No, ma'am.
Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
There is a sufficient factual basis in your case, and you are alert and intelligent. The court adjudicates you guilty, orders credit for time served in the amount of how many days?
Days.
I'm sorry.
2 days, Your Honor.
2 days, and orders you to not return to 1045 29th Street, Orlando, Florida, and pay all mandatory court costs within 180 days of your release, and I am ordering your release as to this charge.
Thank you, Your Honor.
You have the right to appeal this sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir. Paulette Rither,
Your Honor, she'll be entering into a plea to resolve her case.
thank you. Plea of no contest.
Yes, Your Honor. The offer is adjudication of guilt, credit for time served, court cost, cost of prosecution, and no return to 1045 29th Street, Orlando, Florida.
Thank you. Ms. Rither, is this your signature on this document being handed to me, this plea form? Yes or no?
Yes, I have to sign the form.
You signed it. If this is your signature is what I'm asking you.
Yeah, I signed it. Yeah, there's something
Right.
bad.
Did you read the plea form before you signed it?
Yes, yes.
Did you have any questions about anything on the plea form?
No question.
Are you under the influence of any alcohol or drugs and medicine?
Never in my life.
Do you understand a conviction on your case will subject you to deportation if you're not a U.S. citizen?
Yes, I am U.S. citizen, Asian U.S. citizen.
Okay, you understand that, though?
Yes, I do understand.
Right, there's a sufficient factual basis, and you're alert and you're intelligent, and I'll adjudicate you guilty. Order
2 days, time.
2 days with credit for 2 days' time served. Order you to pay all mandatory court costs associated with the charge within 180 days of your release. I'm releasing you as to this charge,
Yes, ma'am.
and I am ordering you to not return to 1045 29th Street, Orlando, Florida.
Well, 29 Street, what you mean?
The location,
I have to go pick up my clothes. Can I have a stuff?
you have to go do what?
Did she get a one-time return, Your Honor?
Yes.
Okay, yes, you are allowed a one-time return for your personal belongings. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of
Can I say
today's date.
something?
Yes,
They close, they church, they don't have no church, they won't be closed because every time I be there, the pastor come pray. If I'm not here, I don't even see the church is open, okay? I'm go call the pastor and
we'll just find you a different church to go to.
okay, God bless you, okay?
God bless you. You too. All right, I've been loved. Joshua Robinson, in your case, the court finds probable cause for battery.
Yeah, what is it?
Battery. And I am ordering a bond of $500, ordering you to have no contact with the victim, not return, possess no weapons and no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. Thank you.
Is it?
That's it, sir. Eric Allen Tower. Bonded per jail staff. Okay. Akeem Woods.
How you doing today, Your Honor?
There's an
Hi
offer,
there, sir.
sorry, there's an offer to resolve his case, Your Honor.
Okay.
It's an adjudication of guilt, a no contest, adjudication of guilt, credit for time served, court cost, cost of prosecution, no return to Carmen Behavior Services, 5959 Lake Eleanor Drive.
And how much time served does this gentleman have?
Days.
Okay. Mr. Woods, is this your signature here at the bottom of this plea form?
Yeah.
Did you read the plea form before you signed it?
Not really. She just told me what it was, so.
Okay, here you go. We'll give you a chance to read it. And once you've read it, we'll recall your case.
Credit for time served. I was like, yep, it's cool.
I just want you to know that you signed something and you need to read it before you sign it, okay? All right, we'll pass your case and I'm gonna go to the next case. Billy Ortiz.
Hello, ma'am.
In your case, you were picked up for violation of conditions of pretrial release. There are multiple violations and bond will stay set at no bond.
Ma'am, can I ask what that was? Because I was in a program for trans.
Okay, yes, ma'am. Let me give you the violations. You failed to appear on August 30th, 2022 for an appointment. After making contact or attempting to make contact again, they found out that the phone number that you had given was not in service. An appointment letter was emailed and mailed to your address with instructions to report on September 12th, but you failed to appear again. A final appointment letter was emailed and mailed with instructions to report on September 21st. Yet another failure to appear.
Ma'am, with that being said, I was on court on September 27th.
Nevertheless, ma'am, bond will stay set at no bond.
Your Honor,
Yes, ma'am.
she actually is entitled to a bond. She has just violated her pretrial release conditions.
Well, you can take that up with Judge Jewett, who ordered no bond. Since
Yes,
he ordered no bond, it's gonna stay at no bond. James Robert Perkins. Mr. Perkins. You were picked up for failure to appear on a criminal mischief charge. Bond's gonna stay at $500. William Jacobs. Mr. Jacobs, you were picked up for failure to appear on a DUI charge, and bond's gonna stay at $2,000. Thank you, Mr. Jacobs. Okay. Darwin Monroe,
He bond.
previously bonded per jail staff. Kenneth Davis. Mr. Davis. Kenneth Lee Davis.
Do you have a booking number?
Your Honor, that's way down.
Yes, I have inmate number 220239881.
This is the add-on.
He's later in the document. It's two Davises as well, but both of the Davises are later on.
Well, this is the Davis I have right now. I mean, I can just put it to the side and we can just keep on calling until he's in line.
Okay.
Okay, Jerez Adderley. Okay, in the restroom, all right. Okay, I'll pull that one to the side. Samuel Bagley.
Yes, Samuel Bagley.
All right, the court finds probable cause for trafficking in an oxycodone greater than 7 grams and less than 14 grams. bond stays at $100,000. And count 2, possession of cocaine, bond stays at $1,000. Thank you, sir. Okay, this gentleman is now ready. Akeem Woods, I'm recalling your case. All right, your counsel has indicated you wish to enter a plea of no contest, is that correct?
Yes, ma'am.
Have you now had an opportunity to read this plea form?
I have, ma'am.
Yes?
Yes, I have.
And this is your signature at the bottom?
I wrote it.
Yes?
I wrote it, yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine?
Not at all, ma'am.
Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, understood.
All right, I find that there is a sufficient factual basis in your case, and I find you to be alert and intelligent. You are adjudicated guilty.
2 days.
You're ordered to serve 2 days in jail with credit for the 2 days you've already served, and ordered to pay all court costs associated with the charge within 180 days of your release. And I am ordering you to be released as to this charge.
Thank you, ma'am.
You're ordered to not return to Carmen Behavioral Services on 5959 Lake Eleanor Drive, Orlando, Florida.
Thank you, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. And I thank you.
Thank you. Have a good one.
Okay. Recalling Jerez Adderley. Mr. Adderley, the court finds probable cause for, in your case, for possession of cannabis greater than 20 grams, and I order a bond of $1,000. Thank you. Alexis Bonilla. In your case, the court finds probable cause for possession of cannabis with the intent to distribute and sets a bond of $1,000. Thank you. And Dana Dwayne Brown. In your case, the court finds probable cause for burglary of a conveyance and bond stays at $3,500. You're ordered to have no contact with the victim and not return to where this incident occurred. Thanks, sir. Catherine Brown. You were picked up for failure to appear, and bond will stay set at no bond on that. And given the fact that bond stays at no bond, even though you don't qualify for the public defender, I'm appointing the public defender since you have no bond and you're incarcerated. The public defender is appointed. Oh, did she have an attorney? Did they file a notice of appearance?
The judge who warrant for no bond. I'm gonna have,
Okay, I'm appointing a public defender.
yeah, but she didn't put the warrant, the other judge who set the warrant put no bond.
Okay. See another.
Yes, for your next court date, yeah.
Kadarius Deshaun Butler.
Your Honor, he qualifies for pretrial.
I'll order you to be released pretrial release on the charge of fleeing and eluding a law enforcement officer with lights and sirens, for which I do find probable cause. You are ordered to comply with all the conditions of pretrial release.
Yes, ma'am.
Thank you. Kenneth Davis. Mr. Davis. Let me be sure I got the right Davis. Okay, now Kenneth Lee Davis Jr.? Okay, let's see, do you have a different date of birth on these, or is it the same? All right, are you the Kenneth Davis with the date of birth July 7, 1984? Okay, got the right case. In your case, count 1, robbery, I find probable cause and order a bond to stay at $5,000. Count 2, possession of methamphetamine, I'll set a bond of $500. Count 3, possession of paraphernalia, I'll set a bond of $150. Count 4, battery, bond will stay at $500. You're ordered to have no contact with the victim, not return, possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. I will revoke your ROR and order a new bond on your 2022 CF 8462 case of 1,500 on count 1 and 500 on count 2.
It's just one count. Second count, no action was taken.
Okay, since no action was taken on count 2, then I will not order a bond on count 2, just count 1. And ROR will remain on count 2.
What was, count two, was it, you stated the bond?
On count 2, I reduced the bond to 500.
Okay, one second. Your Honor, can you repeat the bond for count 1, please?
Yes, on count 1, the bond stayed at 5,000. Any other confirmations? Thank you all. You know, is the other Davis in line yet? No? Okay. All right, okay. Andrew Diaz? Mr. Diaz, in your case, I find probable cause for grand theft of $750, but less than $5,000. And bond stays at $1,000. And count 2, retail theft in coordination with others, and bond stays at $1,000. You're further ordered to not return to the location where this incident occurred
Yes, ma'am.
and have no contact with the victims. Thank you.
Yes, ma'am.
Alan Charles Ford. Alan Ford. All right, Mr. Ford, sir, you're charged with failure to appear on a possession of cocaine charge, and bond is staying at $500.
Is this Ford?
Alan Ford?
He's not here yet.
He's coming, Your Honor.
Oh, that's not him? Oh, okay. I don't know who that is.
Is the other Davis coming, or, you know, Davis?
There's another
Two
Davis.
Okay, let me see the.
There's two Davises. That was Davis Jr. There's another Davis. Book, date of birth is 10.
The booking number is 22023981.
Just for 1 minute when you come up here.
There's two of them.
Okay, well, is it possible to get the other Mr. Davis so we can conduct his initial appearance?
He's on I-11.
That's the one that came in.
No, that's
All right.
he has here.
Are you Alan Ford?
Yes, ma'am.
All right, you were picked up for failing to appear, and your bond will stay set at $500. Underlying charge was possession of cocaine.
All right.
Thanks. Michael Michael Vincent Galasso. Sir, I find probable cause in your case for count 1, possession of cocaine with intent to sell or deliver. Bond stays at $15,000. Count 2, possession of 3,4-methylene methamphetamine MDMA ecstasy. Bond stays at $1,000. And count 4, possession of a concealed weapon by a convicted felon. Bond stays at $4,000. You're ordered to possess no weapons, no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. As to case number 2022 CF 895780, for which you are out on bond, the court will revoke the bond and order a new bond of $5,000 on count 1 and $5,000 on count 2.
Just increase the bond.
Okay, I can't get a bond reduction, ma'am. I have a job and everything, and I have family that's already offering to bond me out. If I can just get a reduction on some of this, please. I know I'm in the wrong.
Not at this time, sir.
I know that I'm in the wrong, ma'am.
Not at this time, sir. And I don't think your lawyer wants you confessing on the record
I understand.
in court.
I'm not trying to put nothing on me. I'm just saying, I'm already.
I'm not going to reduce the bond at this time. Your lawyer can file a motion before the judges that are assigned to the 2 cases.
There's nothing you can do, man.
No, sir.
Thank you.
Autumn Grove.
She mental health, Your Honor.
She qualifies for pretrial.
What?
She qualifies for pretrial release and she's mental health?
We can possibly roll her till tomorrow, Your Honor, to see whether or not she's gonna be released from mental health.
Certainly. We'll reset her. She's on mental health. 24 hours. Travis Hawkins. The court finds probable cause in your case, and bond stays at $1,000, and the charge is petty theft with 2 prior convictions. You're ordered to not return and have no contact with the victim as a condition of your bond.
Your Honor, I apologize. You said the bond is 4,000?
I thought I said 1,000.
Okay, so it is 1,000?
That's what I said, I think. Look at me, I can't even remember if I said 4 or 1. Did I say 4?
Everyone else heard 1, so it
I
was
wrote
just
down
me.
1.
Oh, okay.
It was just me.
1,000. Damon Holmes, I guess it's this mask, as the interpreter said earlier, it sounds differently.
And Your Honor, he qualifies for pretrial.
All right, Mr. Holmes, sir, I am finding probable cause in your case for grand theft, 3rd degree of a motor vehicle, and ordering you to be released on the pretrial release program. You must comply with all conditions of pretrial release. In addition, sir, you are ordered to have no contact with the victim and not return to the location where this incident occurred.
1 minute, Your Honor, I apologize.
Yes. Is this it? That's the whole of it?
Yes.
Yeah,
Thank you, sir. David Keith. Sir, the court finds probable cause in your case for aggravated assault with a firearm and sets a bond of $5,000. As a condition of bond, you're ordered to have no contact with the victim, not return to the location where this incident occurred, possess no weapons and possess no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. Thank you.
They took the firearm.
All right, that's good. Thanks.
Yeah.
Brian Daniel Larimore.
Yep.
In your case, the court finds probable cause for count 1, tampering with physical evidence, and bond stays at $1,000. For count 2, possession of 3,4-methylene methamphetamine, MDMA, ecstasy, the court sets a bond of $100. The court is ordering no action on your out on bond case. Thank you, sir.
Here.
Yalitza Lorenzano, Yalitza?
Do you have a booking number?
Yes. 220-24001.
She bonded, Your Honor.
Martinez Montalvo?
No, Lorenzano, bonded per the jail staff. Okay. The next case is Jarquavius Mack. Are you Jarquavius Mack?
Yes.
Okay. In your case, the court finds probable cause for grand theft, 3rd degree of a motor vehicle. Bond stays at $1,000. Possession of cannabis greater than 20 grams. Bond stays at $1,000. And possession of cannabis with intent to distribute. Bond is set in that charge to $500. Sir, I am ordering, as to your out on bond case, a revocation of the bond and ordering no bond. Well, actually, as to the out on bond case, the court is ordering a revocation of the bond and ordering a new bond on count 1 of $2,000 and a new bond on count 2 of $1,000.
Excuse me, Your Honor, it's on, count 2 is no action.
The grand theft was no action?
Yes.
All right, on count 2, no, the court will not modify the bond. There apparently already was a bond on that one, and it was not filed. Did they just file an information and did not file count two?
And the clerk, of course, it just says no action was, taken for the count two with the grand theft.
No action was taken? All right. The court will take no action as to count two. As to the out on bond case 2022 CF 5889. I'm not sure if that's a 9. Okay, 9AO, but as to count one, I am ordering a new bond of $2,000. All right, sir, thank you. Elias Martinez Montalvo. In your case, the court finds probable cause for failure to register as a sexual offender and ordering a bond of $1,000. As a condition of bond, you must register in accordance with the law within 24 hours of your release. Yes. The other Davis? Okay. Thank you, sir. Mr. Kenneth Lee Davis?
Yes, ma'am.
And Mr. Davis, I want to be sure that you're the Davis that has a date of birth of 10/23/1960. All right, in your case, the court finds probable cause of possession of fentanyl. Count one, bond stays at $1,000, and count two, expired driver's license greater than 6 months, and bond stays at $100. The court is taking no action on your out on bond case.
Thank you, ma'am.
Octavia McKinney? Are you Octavia McKinney? All right, Miss Eugene, please don't talk to Miss McKinney, Miss McKinney, don't talk to Miss Eugene while I go through your cases. You have so many, and I don't want you to miss any of them, okay?
Yes, ma'am.
So then you can chat with her briefly afterwards, okay, if you have a question. So the first case, since there's so many, I'm gonna read the case numbers. 2022 CF 10065. The court finds probable cause for larceny, retail theft of $750 or more, and bond stays at $1,000. You're ordered to not return to the location this incident occurred. Case number 2022 CF 8394, robbery with a weapon. Bond stays at $5,000.
Your Honor?
Yes,
I
ma'am.
don't know if on that one they said you can change it at IA's. However, that is a PBL.
Well, the judge who signed the warrant set it at $5,000. And so I'm gonna leave it at $5,000. I agree with it. After reading the probable cause affidavit, I agree with Judge Caraballo's assessment, and I'm leaving it set at $5,000 as she said it. So I'm not changing it. I'm leaving it as is. I am adding conditions of not return where this incident occurred and no contact with the victim. Case number 2022 CF 11654. The court finds probable cause for grand theft and bond will stay at $500. Conditions, no return to Lowe's. 2022 CF 10799. The court, for grand theft, the court finds probable cause, bond stays at $500. And conditions, stay away from the Lowe's stores. And in this one, the judge is ordering you to stay away from all the Lowe's stores, so don't go back to any Lowe's. You understand? Okay. The next one, 2022 CF 10731 AO. Grand theft, the bond will stay at $500, and I'm adding the condition of no return to where this incident occurred. Next case is 2022 CF 10729AO. Grand theft, not finding probable cause, bond stays at 500. I am adding a condition of no return. And then the next case is 2022 CF 9137AO. Grand theft, bond stays at 2,000. You're ordered to not return to the incident location. Case number 2020 MM 6948AO is a failure to appear. On count 1, bond stays at 1,000, and on count 2, bond stays at 100. That completes all your cases, but ma'am, let me just double check something. On the case involving the robbery with a weapon, 2022 CF 8394AO, in addition to not returning, I am also ordering you to surrender all weapons or firearms and possess no weapons or firearms as a condition of your release. You understand, ma'am? Okay, ma'am, I'm not finished yet. You understand everything?
No,
What don't you understand?
it wasn't a firearm.
Oh, okay, so that's an issue for you to take up with, your lawyer, but that's the order of the court, okay?
Yes, ma'am.
Were you done chatting with her, Ms. Eugene?
No, Your Honor, can I get 1 minute, please?
Yes, ma'am.
Yes, Your Honor, we're done.
All right, thank you, ma'am, you're excused. Christopher McNeely? Are you Christopher McNeely? Okay. In your case, the court finds probable cause for trespass on property after a warning. Bond stays at $500, and count 2, possession of 3,4-methylene methamphetamine MDMA ecstasy. And bond stays at $2,500. The court takes no action on the out on bond matter. Thank you, sir. Javier Morales, in your case, the court finds probable cause for fleeing and attempting to elude a police officer, and bond is set to $4,000. Count 2, driving while your license was revoked as a habitual offender. Bond stays at $2,500. And count 3, petty theft with 2 priors, and the bond is set to $500. You're ordered to not return to the location where this incident occurred, and you are ordered to not drive a motor vehicle without a valid driver's license as a condition of release. Thank you, sir. Angelise Marie Perilla Cruz. Okay, previously bonded for jail staff. Imani Brielle Parker. Imani,
You have a booking number, Your Honor?
220-23976.
Bonded.
All right, previously bonded per jail staff. Corey Register.
Yes.
In your case, the court finds probable cause for carrying a concealed firearm. Bond will stay set at $2,500. You're ordered to surrender all weapons and firearms to law enforcement within 24 hours of release and possess no firearms or weapons as a condition of release. Thank you, sir. Billy Robinson.
He refused, Your Honor.
Okay, Ms. Eugene from the public defender, do you wish to waive?
Yes, we can waive, Your Honor.
All right, his appearance is waived. The court finds probable cause. Bond stays at $1,000. Joseph Bunyan.
Mental health, Your Honor.
All right. Would you like to waive?
Yes, Your Honor. We can
All
waive.
right, the court finds probable cause and bond is set at the count 1 to $500. Count 2, bond is set to $500. Count 3, bond stays at $15,000. And count 4, bond is set to $150. The court is, no further conditions. Daniel Sanders.
Good morning. You can call me Colonel.
Okay, Daniel Emmanuel Sanders? Okay. The court finds probable cause as to trafficking in greater than 10 or less than 200 GMS of 3,4-methylene methamphetamine MDMA. Bond stays at $50,000. Count 2, possession of 3,4-methyl methamphetamine MDMA ecstasy greater than 10 grams. Bond stays at $5,000. Thank you, sir.
Your Honor, can I have 1 minute, please? He had a question. I apologize.
Yes, ma'am.
Your Honor, client is stating, is it possible if you could reduce the $50,000 bond to something more affordable for client, Your Honor?
What says the state?
State would object, Your Honor. That is a standard bond for trafficking. He also has 3 felony convictions, 6 misdemeanors, and he also has a failure to appear, Your Honor.
The court will decline to grant that request at this time. Tyree Deontay Smith. In your case, Mr. Smith, you're charged with failure to appear, and bond stays at $10,000 on count 1. Bond stays at $500 on count 2. Bond stays at $500 on count 3.
It's backward.
Sure. You have 3 counts of burglary of a conveyance. Bond stays at $500 on 2 of the counts and $10,000 on the 3rd count. Timothy Temples. The court finds probable cause in your case for a larceny, petty theft, and bond stays at $1,500. You're ordered to have no contact with the victim and not return to the location where this incident occurred. Russell Virgil. Mr. Virgil. In your case, count 1, possession of cannabis with intent to sell or deliver. Bond stays at $1,000. And count 2, possession of cannabis greater than 20 grams. Bond stays at $1,000. The court is revoking the bond on your out on bond case and setting a bond of $2,000 on count 1 and a bond of $30,000 on count 2.
One minute, Your Honor, I apologize.
Yes, ma'am. And the last case, Taisha Janaea Ware.
She bonded.
Okay, previously bonded per jail staff.
Put a note in for your attorney if you're doing a final motion. No, you have that.
$180 days.
You're done.
To pay it? Oh, 90 days to reserve, and 180 on the one to be paid. All right, anything further? If not, court will stand in recess.
Nothing from the state.
We have, Torres, Eusebio.
Okay, so there is something further, so court is not in recess. Okay, what do we have?
No, they just brought him now from the other building. He came out of the building, so.
Do we have a case number? Name and case number.
Alfredo Torres Eusebio, 22 CF 11921. It was rolled to tomorrow for probable cause, Your Honor, because you didn't have the affidavit.
Oh, do I still not have the affidavit? Is that the one from Osceola?
No, Your Honor, this is the murder. It's the first-degree murder. However, the affidavit was not available.
Okay, is it available now?
I have a copy. I haven't been able to print it yet, and I haven't been able to show it to defense. Do you want me to do
Okay.
that, or do you just want to deal with it tomorrow?
Is he here, or where is he? Right outside? Then we can do it now.
Okay.
Your Honor,
Yes, ma'am.
can we possibly readdress Mr. Timothy Temples?
Possibly.
Can we address Mr. Timothy Temples, please?
Well, possibly.
Yes.
What does he want?
Okay, so his bond was set at $1,500. This is the only thing holding him in custody. He's asking if possible if we can release him on his own recognizance, ROR him, in regards to this case.
Yes, we can address that. What says the state?
Your Honor, he was just convicted 3 days ago of loitering or prowling and trespassing.
Keep harassing me.
And then this happened on October 12th,
Yeah.
and this is a charge of theft.
Yes, Your Honor.
I'll decline to ROR him at this time. Thank you. Alfredo Torres. Eusebio. All right, in your case, sir, the court finds probable cause for count 1, murder in the first degree, count 2, attempted first-degree murder with a firearm, and the court orders no bond as to both counts. The court's ordering you to have no contact with the victim and no contact with the witnesses or witness in this case, well, witnesses in this case. The court is ordering to possess no weapons and firearms and surrender any weapons or firearms to law enforcement. All right, and the court's canceling the order to reset this for tomorrow since I have handled it today. Thank you all.
I just want to speak up for 1 minute, Your Honor.
Court stands in recess. Mr. White, good morning. In your case, you were picked up on an out-of-county warrant from Osceola County. Bond will stay set at no bond in that case.
I would like to talk, Your Honor. What?
Sir,
I would
keep
like
your
to
mask on.
I would like to talk, Your Honor. I stayed in Kissimmee County. They still my wallet and my cash over $2,000. I did receipt on. I got home tonight. I'm still trying to get myself together. Social Security. You still give me a hard time. And my parents want to sue them. So I don't understand this case. And I'm not be arrested at all. I still want mine over.
Unfortunately, sir, there's nothing I can do to address that concern this morning.
I don't feel I'm supposed to be in jail for this anyway. I did not be arrested for them because I don't have no word to me. They're still my wallet, and over took out of my door. I still had to receive it because of the county. I don't want to move them. Still homeless today. I'm trying to get back to Social Security, phone charge paying orders for this country.
So I have appointed the public defender to represent you. And the public defender is your advocate and can address your concerns after having a consultation with you, they may have more detailed information and be able to address your concerns more appropriately.
Y'all appreciate that.
But I cannot address those concerns today.
What? You have what? Okay.
Thank you, sir. I'm Jonathan Passmore. Mr. Passmore, in your case, you were picked up for violation of your probation, Condition E, a new law violation of petty theft on or about September 26, 2022, for which bond shall stay set at no bond. Thank you, sir. Gus Fennell Jr. Gus Fennell Jr.
Good morning.
Good morning. All right, are you Gus Fennell Jr.? Yes, ma'am. Okay. Are you here, ma'am? Can you tell us your name?
My name is Leisha Gaskin. Good morning. My name is Leisha Gaskin.
Good morning. Gaskin?
That is correct, ma'am.
Okay, Ms. Gaskin, I'm going to ask you to raise your right hand to be sworn in, and everyone in the audience, please stand and raise your right hand to be sworn in at the same time.
Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, thank you. Everyone can sit down except for Ms. Gaskin. Ms. Gaskin, so in this case, Mr. Gus Fennell, sir, you're charged with battery on a law enforcement officer, for which the court does find probable cause. Bond will be set at or stayed at $2,500 in this case. Ms. Gaskin, what input do you believe you have regarding this case this morning?
With the case, I would like for him to be able to get affordable bond so he can get out. We don't have kids together, but we co-parent together. He have 3 small kids. He's an outstanding father. He's very great. It was a misunderstanding that we had in the past. We reconciled.
Hold on a minute, ma'am.
Our problem.
This charge is a battery on a law enforcement officer. This charge has nothing to do with you.
I don't know nothing about that.
Your Honor, if I can, there is another case, 22MM6658. That is a battery domestic violence, and Ms. Gaskin is the victim in that case.
Okay, so Ms. Gaskin, there is a second case, which I haven't read, so I'm going to go ahead and take a moment to look at. Hold on just one moment. So there was a warrant for the second case, battery domestic. The signing judge ordered a bond of no bond. In that case, I would be setting a bond of $500, and if the state and the defense wish to inquire of you, they may do so, but I want both the state and the defense, and you can hear this too, Ms. Gaskin.
Yes, ma'am.
To be aware of something else. In this case, after finding probable cause for the battery on a law enforcement, I reviewed the defendant's out on bond case, a felony case, tampering with the witness to hinder communication, count 2 ag battery with great bodily harm, false imprisonment, and there was a bond of $21,000 on that case. And this court had considered that the court would revoke the bond and order no bond on that case. So I'm just putting everyone on notice about that. Ma'am, what that means is that even if I give him a bond, in which I will on both of the 2 new cases, I'm not going to allow his current bond to remain in effect on the out on bond case, since I have found probable cause for the first case. And in this battery case against you, I'm finding probable cause. So I just want you to be aware of that, okay? State, do you want to ask her any specific questions?
Yeah, so we still could be able to have contact, correct?
That is what we'll determine right now. Let me just ask the state if they want to ask you any specific questions.
No, Your Honor. Ms. Gaskin has already indicated that she would like to have contact with the defendant.
Okay.
So no.
And just to put it out there on the record, moving forward with this case here, I'm gonna drop the charges. I'm just moving forward. I just want it on the record for everybody to know that those charges, this domestic violence case right here is gonna be dropped. I'm going down there and I'm gonna drop the charges.
So, Ms. Gaskin, let me just inform you that it will be the state's decision.
I got that. I got that clearly. I don't mean to cut you off, ma'am. I'm sorry. I got that. I know, but enough is enough. I mean, like.
All right, ma'am, since you understand, let me just go ahead and finish making my order specific so that the clerk can record it. As to case number 2022 MM6658AO, the court orders a bond of $500. I find probable cause. And I am ordering no hostile contact, that the defendant possess no weapons and possess no firearms, and that the defendant surrender any weapons or firearms to law enforcement within 24 hours of release. As to felony case number 2022 CF 7749AO, the court revokes the bond and orders no bond on all counts. And I believe I had completed ordering the bond on the first case at $2,500. Okay, no further conditions on that bond. Thank you.
Ma'am, could I ask a question, Your Honor?
Yes, ma'am.
The ones that you just revoked, what it will take for him to be reinstated a bond on those no bonds?
So he is represented by legal counsel, and that is a legal question for his lawyer to answer. He's represented by the public defender.
Mr. Leon Cheeks.
I'm not sure.
That would be regional.
Yeah, regional counsel Leon Cheeks.
Okay, then that would be a question for him.
Okay, so I have to get in touch with him.
All right, best luck, ma'am. Thank you.
All right, so I can't have contact with him, so I could, like, if I want to come to visit him at the jailhouse and stuff, it won't stop me or nothing like that. I don't want to waste nobody's time.
No, ma'am, I did not order no contact. I ordered no hostile contact. If you want to visit him, you may do so.
Okay, thank you very much.
All right, thank you
All right.
too.
Okay, I have the Creole.
All right, we have the Creole interpreter, so I'm recalling Montilla Felix.
It should be on. Hello?
Is there anyone on the line? This is Judge Allen calling from court.
Good morning, Judge Allen. This is the interpreter. My name is Michael, ID number 111427 for Haitian Creole.
All right, thank you, Michael. We are also attempting to add in another person to this call to do a conference.
Okay, thank you. Sure.
Okay, I'm going to try to connect you. Hold on, please. No, it's not going to do it. I don't know if she could do it. She's gone. She's gone. I don't know how to do it.
How do you know you can't do two?
It's just gonna get busy.
Have you ever tried it before, or is this the first time?
That's the first time.
But you're saying you can't do two. I mean, it's a phone, why can't you do two? Why can't you?
Mine is busy.
Is there another phone in here? Do you have a phone at your station? Okay. Okay, well, I need more details than just you telling me it's not gonna work. Why is it not gonna work? Okay, so what's this wrong person that you're talking about? What's that? So you dialed, you hung up on the interpreter and dialed the witness? Okay, so you talked to someone, and when you were talking to that person, if it had been the correct person, why could we not put that person on the speaker and do the hearing?
Because two calls can't go on at the same time.
What's the phone number again, Miss Keys? No, read it out to me. 239
247
247
39
3910. So dial that number again, Madam Clerk.
Yes.
Dial the number that Ms. Keys just read out, 239-247-3910, and put them on speaker. Ms. Keys, what did you say her name was?
Sony.
Sonny.
Sony. S-O-N-Y.
Sony. Good morning, this is Judge Allen. I'm calling for Sony. Is this Sony?
Yeah, this is Sonny.
All right, good morning, Sony. Do you speak English?
I cannot understand. I cannot hear from you so good.
Okay. I'm wondering if you speak English or if you need an interpreter for another language.
Hello?
Hello? I'm still here.
Question for me. I cannot hear you so good.
Okay. Do you speak English?
Hello, hello.
Madam Clerk.
Oh, what happened?
No, I'm still here. Don't hang up. Don't hang up. Can that stretch all the way over here? Take him off speaker. Sony, I just need to know if you speak English. Okay, and Sony, can you give me your full name? S-O-N-Y, Madam Clerk, write this down. S-O-N-Y, spell your last name. D O U Y O N. One moment, Sony, just one moment. Madam from PTR, Ms. Keys, is that the person that you had contact with earlier?
I didn't have contact with them.
Or is that
My
the person your
supervisor-
office had contact
Yes.
with earlier?
Yes, I mean,
That name?
Yes.
That I just spelled into the record?
yes.
Okay. Are you familiar with Montilia Felix? Okay, so hold on just one moment. We're going to try to coordinate a hearing with you and Mr. Felix and an interpreter. Just hold on, please. Now, let's see if you can do it. That is the correct person. Let's see if you can merge the calls. Just give it a try. The interpreter is busy. Okay,
I'm sorry, the interpreter is still here on the line. This is the interpreter here.
all right. So the interpreter is on the line. Can you merge the calls or not? All right. Mr. Interpreter,
Yes, this is the interpreter here.
can I ask you a question, sir? Just a few moments
Sure.
ago, I was busy talking with a witness. Could you hear me when I was talking to that witness?
Yes, I was able to hear you. Yes.
So we're going to go ahead on and get the witness back on the line, and we're going to see if you and the witness can both be heard at the same time. And if not, then we're just going to go ahead on and cancel the witness, but we're going to go ahead and at least give it a shot, okay? Don't you hang up.
Okay. Absolutely, I will be there.
Okay, thank you.
Sure, you're welcome.
It has to be on speaker. Sony, this is Judge Allen again. Can you hear me? Hello?
You want me to say that, Judge, or no?
Yes, go ahead.
Ok, Sonny, est-ce que c'est Judge Allen qui a parlé ensemble avant? Est-ce qu'on entend voir nous tous les deux?
I don't think he can hear.
I couldn't hear
Stop
the
microphone.
witness. I couldn't hear.
Yeah, if you can. We're gonna try. Sony, we're going to try to call you from a different phone. Mr. Interpreter, I don't know what we're gonna, it's not working, okay.
Okay,
Hold on 1 minute.
sure.
Okay, Sony, can you hear me?
I'm here.
Hi. All right, Mr. Interpreter, can you see if Sony can hear you?
Sure, let me try. Sonny, est-ce que vous entendez voir bien, s'il vous plaît? Entendez-moi? Sonny, est-ce que vous entendez voir interprète la qui a parlé avant là? Est-ce que vous entendez voir, s'il vous plaît? It seems no. I didn't have any answer. Perhaps no. They probably cannot hear me.
All right, we're just gonna go ahead and do the hearing as best we can. Mr.
Okay.
Felix, sir, you're charged with battery on a person. No, Sony, I'm talking to Mr. Felix right now. Then I'm gonna talk to you again. Mr. Felix, you're charged with battery on a person 65 years of age or older, or Ms. Felix, sorry. And I do find probable cause for that charge.
Can you interpret that, Judge?
Yes. Michael, you can go ahead and interpret that, please.
Sure, thank you. Félix, je dis qu'on ça, yo porte charge contre parce que ou elle a été frappé au monde qui gagne plus que 65 ans, avait dit nous joindre une cause probable que nous croyons que ou réellement fait ça.
Bah, frappé, non.
c'est mari ça veut m'a vivre. C'est nous lever et puis moi t'a pral sorti. Pas de gen manger dans kay là, moi te fait manger quitter pour lui, pas de gen manger et puis pardon m'a pral sorti à moi dit papi, mon petit garçon dans kay là, moi dit comme ça, bay petit garçon acheter yon manger pour parce que moi pral l'église, m'pa ka gen temps faire manger à jodi. Li dit oui, me dit quand manger m'te quitter pour aller dit me dans frigidaire.
Okay. I did not commit any battery. He's
Et puis lui-même, lui frappe moi. Et puis moi, allez, mêler.
Mr. Interpreter, you have to tell her not to interrupt so you can tell me what she said.
OK, madame, le map traduit ou pas qu'à commencer par parler sur moi pour interrompre. C'est pour
Oui, OK.
traduire avant de continuer.
Yeah.
Okay. The answer provided is, I did not commit any battery. He's my husband, and I live with him. I was ready to go out, and I told him that I don't have enough time to cook, and he can have my son go purchase food for him. And then and he's the one who hit me. I did not hit him, she says.
So, ma'am, we are not going to get into the facts of the case this morning. I appointed the public defender to represent you, and you can discuss the facts of the case with the public defender later.
OK. Madame le dit que nous pas quoi rentrer dans le détail et dans le dossier qu'on y a là, nous avons désigné un avocat public qui pour défendre nous, ou à discuter tout détail ça qui arrive avec avocat que vous choisi pour vous.
So, ma'am, I am setting a bond in your case of $1,500.
OK. Madame nous dit que nous mettons un bon pour l'idiot et bon que nous établis nous mettons c'est $1,500 que lié.
I am ordering you to possess no firearms and no weapons and surrender any firearms or weapons to law enforcement within 24 hours of your release.
OK, nous disons comme ça que nous ou pas supposé gagner aucune arme ou pas supposé utiliser aucune arme du tout, n'importe des armes à feu ou bien n'importe revolver, n'importe arme qu'on a gagné l'idée, supposé bailler autorité armes ça yo, l'en période de 24 heures de temps, supposé remettre toutes les armes qu'on a possédées. I don't have anything. I don't have any.
All right, thank you, ma'am. Miss Eugene from the state. This is, it's not impossible for us to determine whether it should be no contact or no hostile contact, but I need to know if the state wants to ask any specific questions of Sony on the phone. If so, you need to come up here.
Et dit que nous pas compte si c'était là aucune question spécifique que vous demandez Sony, il dit si mon a une question la vie dans téléphone.
And you're just going to have to kind of project into that microphone.
Good morning, sir. Do you want to have contact with your wife?
Il dit bonjour monsieur, demandez-vous est-ce que vous voulez pour prendre contact avec madame?
Sony, the state attorney is asking, do you want to have contact with your wife?
Monsieur Sony, state attorney a demandé est-ce que vous voulez prendre contact avec madame?
He said no, not at all.
I have no further questions. Thank you.
All right, Sony, thank you for calling in, and we are going to go ahead on and excuse you now. I am going to order her to have no contact with you.
OK, Sony li dit que merci parce que vous avez les matins li dit, moi pral ordonner pour madame n'a pas supposé prendre aucun contact avec du tout.
Do you have any questions, Sony, before you hang up?
Est-ce qu'on a une question vous demander Sony avant de raccrocher?
Yes, sir. He asked, does that mean no telephone calls and no contact at all? And I am saying yes, that's what that means.
Les deux que oui, on dit que oui, c'est comme ça, on pas supposé faire ni contact par téléphone, ni aucun contact du tout.
All right, any other questions, Sony, or are you ready to hang up now?
Sonny, est-ce qu'on parle d'autres questions ou bien est-ce qu'on veut raccrocher qu'on y a là?
Okay, he does not have any other questions, so you can hang up, Sony.
Sonny, on met fermer téléphone, merci.
I am ordering no contact whatsoever. I will allow a one-time visit in the presence of law enforcement to retrieve personal belongings, but it must be in the presence of law enforcement.
Ok, il dit que il a ordonné pour pas pour aucun contact du tout, une seule visite seulement il permet pour une affaire, et avec visite ça, c'est pour autorité aller ensemble avec vous, là on prend les affaires personnelles ou l'encaille là.
And otherwise, no return to the location and maintain a separate residence.
Et puis les deux, autrement, on pas supposé aller l'encaille là, ou supposé à l'habiter de l'autre côté, ou pas supposé à l'habiter de même côté.
And in fact, I think that I'm going to increase the bond from $1,500 to $2,500.
Ok, il dit que n'a pas augmenté l'argent bon au lieu de $1,500, qu'on a mis bon à $2,500.
That's the court's order.
C'est ça que le tribunal a ordonné.
Thank you, ma'am.
Merci, madame.
Thank you, Mr. Interpreter, for your patience.
Thank you, Judge. Thanks for using our services. Have a good day. Thank you.
My pleasure.
Thank you. Bye-bye.
Bye. Eric McCrae.
Good morning, Your Honor. Sean Mendez Callan on behalf of Mr. McCray.
Good morning. All right, Mr. McCrae, in your case, the court finds probable cause for aggravated stalking after an injunction and orders a bond of $5,000. Orders you to have no contact with the victim, possess no weapons, no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. State, do you have any additional recommended conditions?
No, Your Honor.
Thank you. Public defender is not appointed in this case as he's represented by private counsel.
Thank you, Your Honor.
Thank you. Javar Reed.
That's a help, Your Honor.
Ms. Eugene from the Public Defender's Office, I am finding probable cause in this case. If you wish for this person's presence to be waived, you may do so, otherwise I'll reset.
Yes, Your Honor, we can waive his appearance.
All right, his appearance is waived. The court finds probable cause. I'm setting a bond of $250, no return as a condition of release. John Marshall Nicholas. And your first case, the court finds probable cause for criminal mischief. Bond stays at $1,000. In your account 2, violation of domestic injunction, bond is set to $1,500. You're ordered to have no contact with the victim, possess no weapons or firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. In your second and third cases, both for failure to appear, bond will stay set at no bond on both of those cases. Thank you, sir.
When do I get another court date for the failure to appear, Your Honor?
How does the court dates work? Arraignment.
This week.
You'll have an in-jail arraignment, and that will be your next court date, an in-jail arraignment.
In-jail arraignment?
Yes.
Will they set bond at the arraignment?
I don't believe so. I believe your attorney will need to set a hearing before the judge.
Okay.
Okay.
Thank you.
Your Honor, I apologize, I missed it. So for the first case with the criminal mischief and the violation of domestic injunction, can you give me the bond amounts again? I apologize.
On count 1, $1,000. On count 2, $1,500.
Thank you.
Donovan Thomas. Sir, in your case, the court finds probable cause for aggravated assault with a firearm, and I am ordering there's a witness. Ma'am, You've been sworn in. If you were here earlier, I swore everybody in at the same time. You were here? No, you were not here?
Yes, I was here.
Okay. What is your name, ma'am?
Aseta Hannam.
Can you speak a little louder?
Aseta Hannam.
Hannon?
Hannam.
Spell your last name.
Hannam.
Thank you, Ms. Hannum. All right, you're already under oath. Either the state or defense may have questions of you. Ma'am, you're soft-spoken, and I'm going to need you to speak into that microphone so I can hear everything you're saying, okay?
Good morning, ma'am. Hello. How do you know the defendant?
We've been together for almost 3 years.
When you say together, you mean in a romantic relationship?
Yes, we were living together.
Okay. While this case is pending, do you want to have contact with him?
No.
Okay.
I need a restraining order.
Has something like this happened before?
Yes.
Were drugs or alcohol involved in this incident?
No.
I have no further questions. Thank you.
You're welcome.
Thank you, ma'am. Does the defense have any questions?
No, Your Honor.
All right, the court orders a bond of $5,000, orders no contact with the victim, no return with the exception of one time in the presence of law enforcement to recover personal effects, no possession of firearms or weapons, and surrender all firearms or weapons in your possession to law enforcement within 24 hours of release. Thank you.
Your Honor, one moment. I just need to confirm. I think this actually happened at...
One moment. You want me to order to maintain separate residence?
Yes, Your Honor, because I think this actually happened at his house.
Okay, I'll also order to maintain a separate residence. Thank you. Ernest Williams. Mr. Williams? In your case, we're not sure how much income you make. Do you get paid weekly or monthly?
Ma'am?
You filled out your application for the public defender, and I would like to appoint them if you qualify. So when you get paid, do you get paid every single week or every month?
Every week, ma'am.
Every week? Okay. You don't qualify for the public defender based on that information. However, sir, I do find probable cause as to count one. Yeah, I'm going to go ahead and appoint the public defender because I'm ordering no bond as to count one. And so you won't be making your income. So you'll qualify. And I'm going to order $150 bond on, count one is burglary of a dwelling with an assault or a battery. Count two, tampering with a witness to hinder communication. I'll order a bond of $150. Count three, battery, domestic violence. I'll order a bond of $500. Further, you have 2 cases of failure to appear. Both cases, the bond will stay set at no bond. Conditions of release, sir, are that you have no contact with the victim, no return, possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of your release.
Your Honor, I apologize. I was speaking to client. Can I get the bonds one more time, please?
Yes, ma'am. No bond on count one. 150 on count two. 500 on count three. No bond on both failure to appear cases.
Your Honor, I only have one failure to appear case.
Oh, why do I think it's 2? Well, if everybody else has 1, then that means I just looked at it twice. So no bond on the 1 failure to appear case. Joseph Carell, in your case, the court finds probable cause for violation of a domestic violence injunction, and there's a witness. Ma'am, you were sworn in earlier.
Yes, ma'am.
Okay, so one of the attorneys or both may have questions of you. What's your name?
Kelly Veith,
Spell your last name.
V as in Victor, E-I-T-H.
Okay, thank you, Ms. Veith. State, you may inquire.
Good morning, ma'am.
Good morning.
How do you know the defendant?
He's my ex-boyfriend and the father of my child.
And the injunction was already in place, correct?
Yes, ma'am. There were not initial charges, well, there were charges pressed on him originally with the initial battery, but he was never arrested. There was an injunction in place. We were able to have time sharing with our child, which is why he was there. He became hostile with me, threw a pen at my face, smashed my cell phone, which was preventing me from calling help. Luckily, I called help prior to that. I am requesting protection for my child and myself. I'm requesting no visitation at this time until a court order is granted.
Thank you very much for coming in. I have no further questions, Your Honor.
All right, Ms. Eugene from the Public Defender?
No questions, Your Honor.
All right, she's asking no contact with the child at this time. Any objection to the court entering that order?
1 second, Your Honor.
With all due respect, Your Honor, I don't know that you have the jurisdiction to order that, as the child is not the victim.
I'm going to consider it, I'm going to have her inquire of her client. But I agree, I'm not going to order it if he doesn't agree to it, not at this time.
As of now, he says it's fine, Your Honor.
Okay, ma'am, I am going to grant that request because the defendant is in agreement to it, but I really could not grant that request if he didn't agree to it. Do you understand?
Yes, ma'am. There's motions in place to modify our current injunction regarding time sharing.
Okay, so at this time, the court orders as follows: a bond of $500, no contact with the victim, no contact with the minor, a child that the victim and defendant share in common, without a further order of the court allowing contact. So that means it can be changed or modified in the future. No return. Maintain at least 500 feet from the victim and the victims and the minor child. Possess no weapons and no firearms, and surrender all weapons and firearms to law enforcement within 24 hours of release. All right, thank you, sir. Thank you, ma'am.
I have one quick question.
All right, one moment. She has a question. Yes, ma'am.
It may be for the state's attorney. What is going on with the initial battery?
I apologize, ma'am. At this time, I don't have that information. However, if you call our main number and give either your information or the defendant's, they should be able to tell you that.
Okay, thank you.
Thank you, ma'am. Okay, Angelo Davis. Right, Ms. Eugene from the Public Defender, do you wish to waive their presence?
Yes, Your Honor, we can waive.
All right, the court does find probable cause for battery and sets a bond of $500, no contact, no return, with the exception of a one-time visit with law enforcement. Possess no weapons, no firearms, surrender weapons and firearms to law enforcement within 24 hours of release. The court is taking no action on the out on bond case. Jesse James Figueroa.
Morning.
Good morning, sir. In your case, the court finds probable cause for battery, dating violence, and I am ordering a $500 bond, no contact with the victim, no return, possess no weapons, no firearms, and surrender all weapons and firearms to law enforcement within 24 hours of release. I am further ordering a revocation of the bond on your out on bond case and ordering no bond on all counts.
Your Honor, if I may, no information has been filed in that felony case, so I would like to argue that you do not revoke that bond because no information has been filed yet.
If no information has been filed, then I will not take any action. State, can you confirm that no information has been filed?
Formal charges haven't been filed, Your Honor. However, he was just arrested September 25th.
So what says the state? Do you want me to revoke the bond?
Your Honor, if possible, can you revoke and double? He does not have any history, but it is concerning that he was already out on bond. The charges being battery on a Leo ×2.
right?
And resisting with violence.
Right.
And he's now charged with battery again.
And then there's an assault charge as well, and I didn't know who the assault was on. I wasn't presumptuous or assumed it was the same victim, but the nature of the charges are similar. So the court's going to maintain the court's original order and no bond, revoke bond, no bond.
Your Honor, client is stating that, can we roll this to tomorrow so he can have time to hire a private attorney? Do you have one? He's saying that he has a private attorney, so can we roll this to tomorrow so his private attorney can come in my place?
Does the state have any objection to that?
No, Your Honor.
Okay. Yes, we'll reset it. Sir, at this time, I want you to be clear. The public defender does represent you. Do you understand?
Oh, sorry.
You understand?
Not sure I fully understand.
Does he speak English?
Yeah, I speak English. I'm sorry. Yeah.
Oh, okay. Do you understand that at this point in time, the public defender represents you?
Yeah,
And if your attorney, I'm going to roll it to tomorrow, and if nobody shows up, then the public defender is still your attorney, okay? You understand?
I understand.
Unless the attorney shows up. I'm granting your request because you want to give your attorney an opportunity to come. I don't know if you guys have been coordinating or communicating effectively, but if no one shows up tomorrow, she's representing you. You understand?
I appreciate her too. I did this to myself last night, so.
Okay. I'm going to reset for 24 hours per defense request.
Are you gonna revoke the bond, or are you gonna?
I
Your Honor.
revoke the bond, yes. Yeah. I'll readdress all issues in the morning, but I am resetting for 24 hours for a rehearing. Reset
Your
for a
Honor.
rehearing. Yes? Did somebody say something? Someone said, Your Honor? Oh, thank you. You're welcome. Beatrice Matos?
She's downtown court, Your Honor.
Downtown at court. Would you like to waive, Ms. Eugene, from the
Roll
public
it for
defender?
tomorrow, Your Honor.
Okay, I'll reset for tomorrow, 24 hours. Defendant was downtown in a different court. Giovanni Cabrera.
Morning.
Good morning. The court finds probable cause in each of your counts, count 1. Oh, wait, actually, I take that back, sorry. I do not find probable cause. I need more information to find probable cause. I have some information, but it seems like it's secondhand information.
Your Honor, this is an out-of-county warrant.
Oh, it's in an out-of-county warrant? Oh, it looks like a probable cause.
Your Honor, it's an over-the-line arrest from Osceola.
Yeah, it's an over-the-line arrest. It says probable cause, so I need to know that there was probable cause to make that over-the-line arrest. I don't have anything to support that other than hearsay. So can I get additional information on that?
If you will give me that.
24 hours?
Can you give me the name and case number, please, Your Honor?
I can give you the name, but there is no case number. It just says Osceola over-the-line arrest.
Okay.
Giovanni Cabrera.
Yes, Your Honor, the 24 hours, please.
Okay, reset for 24 hours. For probable cause. Paris Green.
Be bonded, Your Honor.
Bonded per the jail staff. Santrell Green. Good morning. You were picked up on an out-of-county warrant from Volusia County for fleeing to elude and burglary of an occupied dwelling. Bond stays at no bond on both counts.
That's a probation violation, man. Volusia County.
It may.
Had a dirty urine. That's all.
It may be, but either way, the bond will stay at no bond.
Yes, ma'am.
Okay.
Is there any way they could put a motion to expedite me down there so I can get it over with?
The public defender represents you, and they can inform you of whether or not that's possible.
Then I'll have the attorney that, our office reach out to them, then the public defender there, right?
I just need it.
Okay, then I'll have our office reach out to them.
Thank you. Jesse Howard. All right, this is an out-of-county warrant. Do you wish to waive?
Yes, Your Honor.
All right, his presence is waived, and bond will stay set at no bond. Public defender waived his appearance. Michael Mayhew,
Yes, ma'am.
in your case, you were picked up on an out-of-county warrant from Seminole County for burglary with a battery. Bond will stay at no bond. Thank you, sir.
Is there any way to get a bond, ma'am?
Yes, you'll have to consult with your lawyer about that. Daniel Hales.
Your Honor, he has the HRSO detainer.
Okay, thank you very much. Mr. Hales, in your case, you're picked up for violation of probation, 5 counts of violation of condition 29, failure to submit to electronic monitoring, and you do have a hold. Based on that, I am appointing the public defender, even though according to your income, you do not qualify, but since I'm ordering no bond on the violation of probation, and you have the hold, I am appointing the public defender to represent you.
Can you see, Your Honor, I apologize, what is the hold exactly? I'm unable to see that.
It clears after his appearance, after his initial court appearance, it clears.
Oh, okay.
It was for the HRSO.
Do you still have a question about it, or do you understand now?
I mean, to me, a hold meaning when you're like waiting on somebody else to come get me.
No, go ahead and just tell them what the hold is. Okay. Do you still have a question, Ms. Eugene?
No, Your Honor.
All right, thank you. Brittany Tremaine Jackson,
Yes, ma'am.
in your case, you're charged with violation of probation and bond, condition 5, a new law violation on or about 10/14/21 of petty theft, and bond will stay set at no bond. You're ordered, you have actually a new case also, for which I find probable cause. Dealing in stolen property, bond stays at $2,500, and fraudulent use of personal identification of someone else, bond stays at $1,000. Conditions of bond are no return to 630 Country Club Drive in Winter Park, and no association with the co-defendant, Felton.
I haven't called any new charges, so I don't even know what this is about. Is there any way I can get like a?
Are you Brittany Tremaine Jackson?
Ma'am, but I need an alpha.
Are you Brittany Tremaine
ma'am.
Jackson?
Yes, ma'am.
All right. Is your date of birth 9/20/1995?
Yes, ma'am.
All right. So a warrant was signed by the Honorable Judge Christine Arendes on the 3rd of October, 2022. And I reviewed that warrant, and I reviewed that probable cause this morning, and so, ma'am, that's the case.
I understand.
You can get more information about your charge from your public defender. Thank you, ma'am. Cariana Aisha Kearney.
Yes, ma'am.
In your case, the court, you were picked up for violation of your probation condition E, committing a new law violation of battery, domestic violence on or about September 30th, 2022. Bond will stay set at no bond. Thank you.
What does that mean, though?
Well, you were on probation, you violated probation, the judge ordered no bond, you cannot bond out. That's what it means, pretty much. Do you understand now?
I'll be here for 30 days and then.
Ma'am, you're going to get a court date. First, you'll have an arraignment, and then you'll get a court date, and the judge will inform you of what the ultimate outcome in your case is. I don't know if it's going to be 30 days or 60 days or 90 days. I'm just telling you, you have another court date. Victor Martinez Cruz. In your case, you were picked up for violation of your probation for multiple violations as follows. A special condition, failing to pay court costs and owing a balance of $668 as of September 14th. Special condition, failing to comply with the batterer's intervention program. Condition 2, failing to pay the amount of $20 per month for costs of supervision and being $320 in arrears, for which bond will stay set at no bond. Kashawn Rayner, in your case, you're charged with violation of probation for a new law violation of battery on a law enforcement officer. There's a warrant in Polk County on 9/23/22, and bond will stay set at no bond. Torquenzia Speed, you were picked up for violating your probation. You have multiple violations as follows. Failure to pay costs of supervision, you're $360 in arrears. Special condition by failing to pay court costs. Special condition by failing to complete the impulse control class. And special condition, failing to complete 100 hours of community service. And bond will stay at no bond. Thank you, ma'am. All right, we'll do motions for release. Timothy James Zimmerman.
Denied, information was filed.
All right, that's denied. Anthony Brent Shearer.
Granted, notice of non-filing. I apologize, I cut you off before you did the case number, I apologize.
I wasn't doing the case number unless there's more than one, but that's fine. I'll grant that.
Your Honor, I'll do the case numbers then, only because sometimes mistakes are made.
That's fine.
Okay. For Anthony Shearer, it was 22 CF 10590.
All right, thank you. Marquise Dante Chisholm.
22 CF 7783, granted.
All right, that's granted. James Riley Owens.
22 CF 10257, denied, information was filed.
That's denied, thank you. Cornelius Mason Kenny, Kenny Cornelius Mason.
22 MM 6197, denied, information was filed.
That is denied. Brenda Maria Reynolds.
22 CF 6713, granted, notice of non-filing.
Yes, ma'am, that's granted. Kayuna Khadijah Deshay Davis.
22 MM 6108, granted, case was no billed.
And that is granted. Angel M. Santiago Pedrosa.
22 MM 6002, denied, information was filed.
And that is denied. Willie Riley.
22 CF 8010, granted, notice of non-filing.
All right, this motion's granted. Arlette Duran.
22 CF 9565, denied, information was filed.
That is denied.
Good morning, Judge. For the record, Sean Lyons on behalf of Mr. Duran.
Good morning.
They did file information around 5 o'clock yesterday for this hearing, so that's why it is denied.
Okay, thank you, counsel. Miguel Galar, oh, wow, okay. Maybe it's Galarza Villalobos?
22 CF 10489, granted, notice of non-filing.
That is granted, defendant's released. Okay.
Your Honor, I understand that you want to go straight through. However, can I have a 10-minute break, please?
I was thinking 15.
Wonderful.
We will all take a 15-minute break.
Your Honor,
Yes.
in regards to the misdemeanor arraignments and the pleables, I'm not sure if the inmates have been brought up, so I haven't been able to speak to any of them.
Well, first of all, let's ask the jail staff, were the inmates brought up? They should be here. Do you want, do you want me to give you 20 minutes instead of 15?
Yes, Your Honor.
All right, I know that's short, so we'll work with it, but I'll just do 20 minutes then instead of 15.
Okay, thank you.
Hopefully that's enough time, but, I mean, realistically, is it?
I have about 10, maybe 25, because I have about like 10 people I need to speak to.
I'm sorry?
Maybe 25, probably 25. I have like 10 people I have to speak to. It could be less.
So why don't we just leave it at 20 minutes and then you just let the deputies know if you're falling behind.
Okay, no problem. Thank you.
Okay, so 20 minutes recess. I hope I signed that. Court's in recess for 20 minutes.
All right, good afternoon, sir.
Buenas tardes, señor.
You're arrested for battery
Usted fue arrestado por agresión
and do find probable cause for your arrest.
y yo he encontrado causa probable motivo fundado para el arresto.
You do qualify for bonds with PTR.
Usted cualifica para fianza con las condiciones de la oficina anterior al juicio.
Your bond will be set at $500.
La fianza va a ser $500
You're not to have any contact with the listed victim.
y no puede tener contacto con la víctima que se ha nombrado.
You're not to return to 2450 Smith Street, Unit
No
A.
puede, no puede regresar al 2450 de West Street en la unidad A.
You're not to possess any weapons or firearms.
Y no puede poseer ninguna arma de fuego ni otra arma peligrosa.
Any additional conditions, state?
No, Your Honor.
No hay ninguna otra condición que pida la fiscalía.
All right, thank you.
Muy bien, gracias. Eso es todo.
Carlos Rojas Araujo, 22 MM 2284. Sir, you've been charged with battery.
Usted está acusado de agresión.
Do find probable cause for your arrest.
Hemos encontrado causa probable motivo fundado para el arresto.
Do not qualify for PTR.
No cualifica para libertad con las condiciones de la oficina de antelación al juicio.
Your bond will be set at $500.
La fianza van a ser $500.
You're not to have any contact with listed victim.
No puede tener contacto con la víctima que se ha nombrado.
You're to maintain a separate residence from the victim.
Tiene que mantener una residencia por separado de esa víctima.
You're not to possess any weapons or firearms.
Y no puede poseer armas de fuego ni ninguna otra arma peligrosa.
Anything else, state?
No, Judge.
Jaime Moreno, case 2020 CF 145. Oh, he does not? Okay. Can you make an announcement to see if anyone else needs services of the Spanish interpreter?
¿Hay alguien más que necesite servicio de traducción a español? Por favor, levante la mano derecha.
All right, I see one person standing up.
Vamos a renunciar a la lectura de cargos.
Is it Ivan? It's probably stuck with something. See if Damien, Ivan. All right. Sir, can you please tell me your first and last name?
Muy bien, por favor, ¿puede decir su primer y Ivan Constancho.
All right, you have a second last name as well. Is it Telez?
My full name is Ivan Andres Constancho Davis.
Do you need the Spanish interpreter?
Well, I understand English.
All right, well, we're gonna be utilizing the Spanish interpreter for these proceedings, okay? So just make sure you just give him an opportunity to interpret for you. Your case number is 22 CF 2923.
El caso es 22 CF 2923.
I'm gonna waive the formal reading of your charges.
Se ha renunciado a la lectura formal de los cargos.
I do find probable cause for this offense.
Yo he determinado causa probable motivo fundado por el delito.
You state you would like to be heard?
Yes,
La
Your Honor.
la fiscalía, si quiere decir algo, dice que sí.
The state is requesting that we hold the defendant at zero bond, that the court find proof evident presumption great.
La fiscalía está solicitando que el acusado sea mantenido en detención sin fianza debido a la gran presunción del caso.
Under Florida Statute 794.011,
Bajo los estatutos de la Florida,
subsection F, it defines physically helpless, which qualifies in this case.
ya que la víctima era físicamente incapaz.
Under subsection 4D, it describes that any of the categories under subsection E1 would make it then a life felony. The first category,
Las leyes requieren que, según se ha redactado esa ley, puede ser hasta cadena perpetua,
and subsection E1 is physically helpless.
ya que la víctima estaba incapacitada físicamente.
As such, this individual has committed a life felony, and the state is asking, based on the report, that the court find the proof is evident, the presumption is great, and we hold the defendant on zero bond.
Por lo tanto, este acusado ha cometido un delito que puede ser un delito grave de hasta cadena perpetua y estamos solicitando que permanezca detenido dado la gran presunción del caso.
All right, defense, would you like to be heard?
Yes, Your Honor. I would object to based on reading the defendant, or the alleged victim wasn't helpless, and that the defendant should be entitled to reasonable bond.
Nosotros estamos aumentando ya que al leer la acusación aparenta ser que la víctima no es incapacitada ni está desposeída y que por lo tanto él debe cualificar para una fianza.
Mr. Rosa, did you read the charging affidavit?
¿Usted leyó la declaración jurada? Sí, su señoría.
And
Yes, Your Honor. The alleged victim got up and they pushed them and left the immediate area, so she wasn't helpless.
Your Honor,
La alegada víctima se puso de pie, lo empujó y abandonó el área, así que no estaba incapacitada.
State.
yes, Your Honor. Just to clarify for purposes of the record, the definition of physically helpless under the statute means unconscious, asleep, or for any other reason, physically unable to communicate, unwillingness to enact. The state was being somewhat vague since the defense requested a waiving of the charges. However, since it's been brought up, the victim in this case was asleep. When she woke up, the defendant was on top of her naked with his penis inside of her vagina and thrust multiple times. The state is asking that he be held no bond.
All right, the court finds probable cause. Court also finds proof is evident, presumption's great. We'll hold you at zero bond. Defense, if you're requesting an author hearing, you can set it in front of the assigned judge.
Muy
Bond is
bien, el
zero.
tribunal está determinando que hay causa probable, está determinando que hay motivo fundado y presunción grande, por lo tanto el acusado va a permanecer detenido sin fianza. Si los abogados desean radicar alguna moción para que se reactive la posibilidad de una fianza, pueden solicitarlo en cualquier momento.
All right, and there is a no contact, even though there's a zero bond.
Y aunque no hay fianza, también hay una orden de no contacto.
All right, thank you.
Gracias, eso es todo.
Is there someone else that needed a Spanish interpreter?
¿Había alguien más que necesite intérprete?
No? Okay, thank you, sir.
You're welcome, Your Honor. Have a good day.
You too. Jaime Moreno, 20 CF 145.
Good morning, Your Honor. Attorney Robert Simon for the record on behalf of Jaime Moreno.
Yes, sir. It's a violation of probation. Bond is set at zero at this time, sir.
Yes, understood, Your Honor. The only issue, we did file a notice of appearance, and if you see in the record, it was before the service of the actual warrant, so the warrant was just served. I don't know if Your Honor would need us to supplement with an additional notice of appearance, or that should be sufficient.
That should be sufficient.
Okay, excellent. Just for the purpose of the record, I appreciate it.
Okay, thank you.
BOP arraignment, October 18, 9 a.m., courtroom 5A.
Stephen Tapley, 21 CT 3497. Mr. Tapley, you failed to appear for a public defender pretrial. Your bond is currently set at zero at this time, sir.
Public defender pretrial, December 14, 8:15 a.m., courtroom 4A.
Regina Carpenter, 22 MM 2278, 22 CF 2703. Ms. Carpenter, your misdemeanor case, which is providing false name or ID by arrestee, I do find probable cause. You do not qualify for PTR. Your bond is currently set at $500. I have also reviewed an arrest warrant for 22 CF 2703 for petty theft, third offense. I do find probable cause. Your bond is set at $500. Your conditions to stay away from all Target stores. Do you understand? Yes, ma'am. Thank you, ma'am. Damian Carpenter, 22 CF 2922.
Your Honor, I also request the waiving of the reading of the charges in this case.
For all 10 counts?
Yes, Your Honor.
All right, I see you standing, State, just one
Thank you,
second.
Judge.
Mr. Carpenter, you have 10 separate charges, and I am going to go through them one by one. As to count 1, I do find probable cause. Your bond is set at $1,000. As to count 2, I do find probable cause. Your bond is set at $1,000. As to count 3, aggravated battery, I do find probable cause. Your bond is going to be set at $3,500. As to count 4, aggravated assault with a deadly weapon, I do find probable cause. Your bond is set at $3,500. Count 5, State, I had an issue with finding probable cause.
The state has no objection to the court RORing on that count, Judge.
Count 5, you will be ROR'd. Count 6, tampering to hinder communication with law enforcement. Do find probable cause. Your bond is set at $1,000. Count 7 is another count of tampering to hinder communication with law enforcement. I do find probable cause. Your bond is set at $1,000. Count 8 is a PBL. State?
Your Honor, the state is asking that the court find that proof is evident, presumption is great, and that the defendant be held no bond on this count.
Defense, would you like to be heard?
No, Your Honor.
Okay. The court does agree with the state. Do find probable cause, and I do find proof is evident and presumption is great. Bond is set at 0. Count 9 is also a PBL. State?
Your Honor, the state is also asking that the court find that there is proof evident, presumption great as to this count, and hold the defendant 0 bond.
Defense, would you like to be heard?
No, Your Honor.
All right, court agrees. I do find probable cause as to count 9, and I do find proof is evident, presumption is great. Defense, if you are requesting an author hearing as to counts 8 and 9, I encourage that you do so in front of the assigned judge. Count 10 is false imprisonment. I do find probable cause. Bond is set at $5,000.
Your Honor, my affidavit reflects count 10 as a kidnapping.
It is, but I don't find probable cause.
I just wanted to make sure the record was clear. Thank you, Judge.
To make it clear, yes, it is stated as kidnapping, but the court did not find probable cause for kidnapping. The court found probable cause for false imprisonment. Yes, ma'am.
What was the bond on count 9?
Count 9 was 0. For the false imprisonment, bond is set at $5,000. The conditions will be, you do not qualify for PTR, but you are to not have any contact with the listed victims. You are not to return to the area. You are not to possess any weapons or firearms. All right, thank you. Dave Donaldson, 22 MM 2280. Mr. Donaldson, you're arrested for trespass. I do find probable cause. You do not qualify for PTR. Your bond's going to be set at $500. Conditions will be not to return to 904 Cypress Parkway, Kissimmee, Florida, and that is the Walmart. Do you understand?
Yes, ma'am.
Thank you. Amelia Enriquez, 22 CF 2925. Okay, Sebastian, come on up. Good afternoon, Ms. Enriquez. You were arrested for battery by strangulation as well as child abuse. I have reviewed the charging affidavit, and I do find probable cause as to each of these counts. Before I tell you what the bond amount is, your son Sebastian is present. Sebastian, can I have your last name? Enriquez. All right, how old are you? 17. All right, go ahead and raise your right hand for me. Do you solemnly swear to tell the truth, the whole truth, nothing but the truth?
Yes, ma'am.
All right, thank you, sir. Don't tell me anything about the facts of the case. I just want to know if you wish to have contact with your mom. Is that a yes? You have to say yes.
Yes.
Okay. We're being recorded, so I need yes or no.
Yes.
Okay. Tell me why you want to have contact with your mom.
Because I feel like this wasn't her fault at all.
Are you afraid at all if she returned home? Okay.
It's my mom.
Do you have any other siblings in the home? You do? How old are they?
16. It was cool every day. He works. He does what he has to do.
All right. So this is what I'm going to do, Sebastian. Your mom can get a bond. So as to count one, I'm going to give her a bond of $1,500. And count two, her bond will be $1,000. And it's going to be with PCR conditions, okay? So she's not to have any hostile contact with you.
What does that mean?
That means that she can't be aggressive towards you. There can't be any yelling or anything like that, okay? Do you understand, Ms. Enriquez? Yes, ma'am. All right. Is there any weapons in the home, Sebastian? All right. I'm just gonna order just no weapons, no firearms, because of this domestic case. And anything else, State?
No, Judge.
All right, thank you.
Your Honor,
All right, yes, ma'am.
because of the nature of the charge, she don't qualify.
She doesn't qualify for PTR, okay. She doesn't qualify for PTR, but my conditions still remain. All right, thank you, ma'am.
And did you say no hostile contact?
No hostile contact, yes. Danny Garcia, 22 CF 2928. All right, we'll reset to tomorrow. Rodrigo Brenda, 22 2282. Sir, you've been charged with trespass after warning. I do find probable cause. You do qualify for direct PTR. Any objections, Dave?
No objection, Judge.
All right, so I just don't want you to go back to the 7-Eleven, okay? Let me get that address. It is 1400 East Osceola Parkway, so please stay away from that area.
I didn't hear it.
You cannot go to the 7-Eleven located at 1400 East Osceola Parkway.
Okay, yeah, I understand that.
Okay, very good. Thank you, sir.
Okay.
Okay, you can have a seat.
What?
Jordan Reese, 22 2283. Mr. Reese, you've been charged with battery. I do find probable cause for this offense. You do not qualify for PTR. Your bond is set at $500. Your conditions of your bond is not to have any contact with the listed victim. You are to maintain a separate residence from the listed victim, and you are not to possess any weapons or firearms. Any other conditions, State?
No, Judge.
All right, thank you. Alan O'Neill, it's Nicholas Allen O'Neill.